Good morning. Good morning, everyone. Thank you for joining and supporting Wait One Legal Minute. I'm Melanie Fenwick Thompson, and today is Tuesday, June 23rd. Tomorrow is my sister's 50th birthday, so I just wanted to start by saying happy birthday to you. Happy birthday to you. Happy birthday. Now, she better watch today. So I'm having some flickering in my electricity. This happened last week. So as usual, bear with me through my technical and electronical difficulties. So I appreciate y'all. If you know my sister, make sure you send her a shout out for her 50th tomorrow. It is nothing like she thought it was going to be. We thought we were going to be somewhere out of the country partying and celebrating her 50 years of life, but COVID had different plans, and that's okay. We are still celebrating her life. So happy birthday, Marnie Fenwick. Happy 50th birthday. So as usual, thank you. If you have any questions about any of the previous conversations, please feel free to share them with me for more discussion. That is the purpose of this platform. I really just want to invoke conversation, share. I want to share my opinion about legal and social issues, and I want you to do the same. So thank you for the support. Thank you for the text messages and the emails with your comments and suggestions about conversations that I should have. And I'm going to keep doing this. So I just need to know who's out there and what questions do you have or what comments do you have. I'm also in the position or open to answering legal questions that I can answer or refer you to someone that can. Last week, I had Taurus Butterfield, affectionately known as Butter, on. He is a criminal defense attorney, and he spoke about some of the issues in the Rayshard Brooks case in terms of, well, what would be favorable for a criminal defense attorney. So I think that was really interesting. We had a lot of comments about that, some frustration, of course, but it's the law. And again, I want to bring that information to you so you understand as this case develops and we get closer to the trial or during the trial, you will understand why some things are going the way they're going. So I want to revisit that conversation. But before I do that, I would like to say that Rayshard Brooks' funeral is today at 1 p.m. Eastern Standard Time at Ebenezer Baptist Church. Yesterday was the public viewing, and today is the private viewing for the family and friends of Rayshard Brooks. So I just want to take a moment to pray for the Brooks family, pray for the families of so many who have lost a loved one by the hands of the law, for the Black community, for our sons, for our fathers, and for our brothers. And I pray for our nation. I pray away the evil in the hearts of so many. We will overcome this divided country. So amen. So the next thing, like I said, I just wanted to touch on some of the information that Butter shared and go more into the charges and how the charges were announced by our district attorney, Paul Howard. As I said, Taurus shared the possible defenses and favorable facts from the perspective of a defense attorney. And we also discussed what facts will not be favorable for a defense attorney. It was very enlightening for many of the viewers, and I think this helps give you perspective about how what hurdles there are for prosecutors in police shootings. It was just very informative information. But today I wanted to have a conversation about the way the charges were announced by Paul Howard. I'm going to start, or try to start, because I have my technical difficulties with my video footage. Let's try to start with this. And let me make sure I have the right one up here. Yes, I do. So this is when, this clip is from when Paul Howard announced the charges last week. And I just want to show a couple things and then have a conversation with you and tell you what my concerns are about the way these charges were announced.
In the videos, we had the opportunity to enhance the videos so that we could get a better look.
So just to start there, what concerns me is that the DA is demonstrating. Good morning, Tony. How are you? As always, thank you for your support. And this is a topic actually that Mr. Harrington texted me. This needs to be talked about. So we were able to touch on it last week, Tony, with Butter, with the criminal defense attorney, but I wanted to revisit it because I didn't go dive into it the way I wanted to dive into it. And I know you, one of my loyal and supportive viewers, wanted to have more discussion about this. So here's my first issue. This Paul Howard opens with an outline of the available evidence to the DA. That is problematic for me. You have a pool of jurors, the community, who is watching the announcement of these charges. And in the announcement of the charges, essentially, this case is being tried. So we start out with an opening of the outline of the available evidence. Problematic for me. So the next issue
we have had an opportunity to do is to view some of the physical evidence. The Chevrolet Trailblazer was a vehicle that was in the line at Wendy's on the night of this incident, and it received a shot from Officer Roth's gun. We've had an opportunity, along with the GBI now, to view that Trailblazer. My office has had an opportunity to inspect the crime scene. We have conducted a canvass of the area. We started our investigation at about 1:15 a.m. on Saturday morning, and we have been working.
I just wanted to pause it again. So not only are you tainting the potential jury pool by laying out your case and laying out the information or evidence that may be used in the trial, but you're telling them, you're going step by step, essentially, of what you've done just to charge the officers that were charged. So that, again, is concerning. He talks about conducting the canvass of the area. I think these are the information that he included is just too much detail for a simple announcement of what charges. I think that generally it's a safe announcement to just announce the actual charges, and that you've done your job. You have done the proper investigations, the proper initial investigations and the initial interview of witnesses, which was sufficient in order to charge the officers in XYZ. I think that you need to tread lightly, because a couple things are happening. You have the community listening to this trial, and listening to the evidence that you have, listening to the things that you've done. So they're developing their own perception prior to the trial, which is what you don't want. You want the jurors to hear the evidence for the first time at the trial. So that should be concerning. I'll play some more. He talks about the preliminary ballistic report. He talks about communicating with the GBI and the police department. So those things are pretty standard, and it's okay to put that out there because those are things that you should do. I'm going to go ahead to this next slide. And this is where I think it just takes the cake for me. I hope this is it. So in this, look at this. I mean, you've got exhibits. I mean, these are probably going to be used in the actual trial as exhibits. I understand that they are damaging, and they certainly weighed heavily in determining.
And these are the charges
Pause here.
for,
Weighed heavily in determining what the charges should be, and that you should charge them. But to use these graphic exhibits for purposes of announcing the charges is concerning to me. Now, I talked about earlier tainting the jury pool in the community. But also, here's my concern. Another concern is a motion for a change of venue. A motion for a change of venue filed by the defense attorneys because they don't think that they're going to get an impartial and a fair pool of jurors. And they're going to, when they go over them, they have those motions, pretrial motions hearings, and they file this motion for, because they will file a motion for a change of venue because they will not want to try this case now in Fulton County, right? So that will be a motion that is filed. And then they're going to go and then they're going to show these slides, this video of the announcement of the charges and the trial that was conducted when the charges were announced. So what's the judge going to do? I don't know if this was a smart move. I've seen some conversation about, let me just say this. This is our an election year. Paul Howard is up against or trying to resume or continue his position as district attorney. He does have a Bonnie Willis is contending against him, and I think that there could be some political undertones, some moves that are trying to be made. I think that this probably made the family feel good, but it may not have been the best thing for the family in pursuing this case properly prior to trial to ensure that this case will, one, stay in Fulton County, and two, there won't be any allegations of any misconduct because of the way these charges were announced, some of the evidence was released. It's just, you want, and I know that it feels good to hear that these officers are being charged. And that is fine, and that should be done, and I certainly agree with that. But my concern is the extent of the information that was shared with the public prior to the actual trial. I don't think that exhibits, enlarged photos, information about the taser. I didn't play that part. The taser logs, all of that information was shared with the general public. That is information that you are going to share as evidence or produce as evidence at your trial. You do not want a jury that has seen this information in the media because you released it prior to a trial. So there are a lot of concerns in the legal community and in Atlanta about why that was done. And I don't know if anyone has any opinion other than maybe the political motivation or something else that I'm not considering. I would like to hear from you, the viewers, because I saw a lot of chatter about the way the charges were announced. So I just wanted to explore that with my supporters and also hear from you because I know that some people who are not looking at the announcement from a legal and or a political perspective were happy to see, were pleased to see the photos, we're pleased to see the video footage, was pleased to see to have that information. So what is your perspective if you aren't looking at it from a legal perspective and you're just trying to draw an opinion as to what happened? What is your opinion about that? The problem with that is this isn't the time to make a decision as to the guilt or innocence of the police officers. It was the time for the DA, for DA Paul Howard, to announce whether or not they will be charged. That was more than appropriate. Another video that I saw, and I did not include that today, but I just wanted to touch on it. A young lady take one of the officers in the George Floyd incident in a grocery store. And her issue was, why are you out in public shopping when you have been charged with the murder of George Floyd? So I didn't include that in here, but I just want to touch on that because it's consistent with the message I'm conveying now. We try people in a court of law. Okay, that is where you lay out your evidence, lay out your case, your facts, and they get an opportunity to respond. That's due process. Why was he in the grocery store? Because he was getting groceries. The officer went to his, I think they even had a first appearance. I mean, that is the law. He does not then have to retreat or not be a part of the community while he awaits trial. This is due process. So I just want to be fair. I want to be reasonable. And I want you all to be aware of what the law is. Once he bonds out, once these officers turn themselves in, they're charged, they turn themselves in, and they bond out if that bond is available to them, and that's the judge's decision. So in the George Floyd case, the decision was made, they bonded out, so they get to, they are out on bond until their trial starts. That's the law. I thought that it was unreasonable for the young lady to question the police officer. And I don't agree with any of these police officers, and in no way am defending any of their actions. But then there's the law, and then there's due process. So I think that the young lady, I understand your frustration. I appreciate your frustration. Believe me, I'm with you. But there's a way to do things. So we just need to be careful about understanding the law, understanding due process, and the positions or the predicaments that we put ourselves in, because you don't want to put yourself in danger either. So that is consistent with this and due process. These police officers now have been charged, and because of the way the charges were announced, in my opinion, was also a trial. So I don't think that is not the way the law works. I think that the charges should have simply been announced, and then allow for the law to run its course. So I don't have much more to say. I will continue to talk about Paul Howard, the charges, and the status of Rayshard Brooks' case, along with following Ahmaud Arbery and following George Floyd's case, and talking about other issues that affect our community. So as always, thank you so much for supporting. I encourage comments and texts about other subject matters to have a conversation about. I appreciate y'all. I will see you on Thursday at 11 o'clock. Every Tuesday and Thursday, I would like to see you all here commenting, and we're going to get better with this, with my technical difficulties and my apparent electrical difficulties, so that we can have a smooth show. So thank you so much for joining, and I will see y'all on Thursday at 11 o'clock.